Every state has a motor vehicle code, and as a driver, you are required to follow it. Or are you?
Yes, you are. Hello, everyone, and welcome back. Today, we're taking another look at a sovereign citizen who is out there in the wild telling others how they too can misinterpret and cherry pick laws to suit their narrative. So sit back and let's go through another sovereign citizen legal scholar's arguments.
I studied the Arizona Motor Vehicle Code, and this is what it said. The provisions of Chapter 3 Traffic and Vehicle Regulations and Chapter 5 Penalties and Procedures for Vehicle Violations refer exclusively to the operation of vehicles on highways. So it's saying this only applies to vehicles. So we need to find out what exactly is a vehicle. Well, the United States Code defines this for us in 18 U.S.C. 31A6. The United States Code defines a motor vehicle, and it says this: the term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property or cargo. So it's only a motor vehicle if it's used for commercial purposes. The United States Code also defines commercial purposes for us in 18 U.S.C. 31A10. It says the term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. So if you are a taxi driver, bus driver, Uber driver, if you're hired to drive truck transporting property, then you have to follow the motor vehicle code because you are driving a motor vehicle because it's being used for commercial purposes. However, if you're just traveling in your car to work or the grocery store, then you do not have to follow the motor vehicle code because you are not driving a motor vehicle. Because remember, it says this refers exclusively to the operation of vehicles, and it's only a vehicle if it's used for commercial purposes. And since you are not using your car for commercial purposes, it's not a vehicle. So you do not have to follow the motor vehicle code.
So what this schnozberry licking sovtard isn't realizing is that of course it only has rules about cars on highways, because pedestrians under normal circumstances are not allowed on highways. Under Arizona 28-796, a pedestrian may walk on the shoulder of the roadway facing oncoming traffic. If you read it, you aren't even allowed to hitchhike because in general, you're not allowed on the highways. They're only allowed to use the shoulder when they absolutely have no other route. And as for the code only talking about vehicles used for commercial uses, well, yeah, of course, because the Constitution and its amendments have given the rights to the states to set the laws regarding civil road use. So you won't find anything in the federal rule book about civil road use.
So that means you have the right to travel without a driver's license or registration. And this is all according to our beautiful U.S. Code. But that's not all. The Supreme Court has also talked about this many times. Here is a U.S. Supreme Court citation from Thompson versus Smith. And they say, the right of a citizen to travel upon the public highways and to transport his or her property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, non-commercial use, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in his person, but in his safe conduct. So we have the right to life, liberty, and the pursuit of happiness.
As for Thompson v. Smith, that's the most commonly referenced case that these legal flat earthers talk about. And we're going to quickly go over that case so we get a little bit of context to this very snipped portion of the overall ruling that these constitutional glue sniffers are providing us.
The circumstances of the revocation of Thompson's permit were these. Prior to the revocation of his permit, he had been twice convicted before the judge of the municipal court of the city of Lynchburg of speeding on the city streets, and on each conviction was fined $50. He did not appear to make any defense on either occasion. On the second trial, the judge of the municipal court at first ordered Thompson's permit revoked, but when it was brought to his attention that the ordinance authorized him to revoke a permit for a conviction of violating the traffic laws only when the defendant has been convicted 3 times within 1 year, he so modified his judgment as to omit the revocation of the permit. Thompson continued to drive his car in the city of Lynchburg for some time after said second conviction, without any interference from the police. But in November 1928, he was summoned to appear before the judge of the municipal court on the charge of driving a car without a permit. When the case was heard, Thompson claimed to have a permit and testified he had not received any notice from anyone that his permit had been revoked. The chief of police testified that he had written Thompson that his permit had been revoked, but that he did not know whether Thompson had gotten the notice or not. The judge of the municipal court held that Thompson could not be convicted on this testimony of driving without a license or permit, but instructed the chief of police to notify him there and then that his permit was revoked. The chief of police then and there in open court notified Thompson that his permit was revoked, but no reason was given at the time for the revocation of his permit by either the judge of the municipal court or by the chief of police. The bill charges that the chief of police in revoking this permit acted under the italicized provision of subsection C of section 134 of the General Ordinances, as amended, hereinbefore quoted, and that the chief of police was without authority to revoke said permit for the following reasons. 1. Thompson had acquired a vested right in his permit prior to the time the ordinance was amended so as to provide for the revocation of permits, and if this amendment is intended to apply to permits granted before it was adopted, it is void, because it violates Section 58 of the Constitution of Virginia, which prohibits the passage of ex post facto laws or laws impairing the obligation of contracts. 2. The provision authorizing the chief of police to revoke the permit of any driver who, in his opinion, becomes unfit to drive an automobile on the streets of the city is void, because it is a delegation of legislative power to an administrative officer, and that it authorizes the chief of police to revoke a permit whenever, in his opinion, the holder thereof has done or omitted to do something, the doing or omission of which the chief of police thinks renders the holder unfit to drive an automobile on the streets of the city, without prescribing any uniform rule, applicable to all persons alike, as to what constitutes unfitness to drive an automobile on the streets of the city, or laying down any rule for the guidance and control of the chief of police in determining what constitutes unfitness to drive an automobile on the streets of the city.
So in short, Thompson v. Smith was about the chief of police arbitrarily deciding that the man should lose his license, and the local judge assisting him in doing so. But because the laws were not uniformly applied, and they were using arbitrary decision-making to deny the man his license in this case, it was actually a violation of his constitutional rights. But what it did say is that they could have done it anyways if he got one more ticket, because that's the same rules everybody else is running under.
Now, if you look up personal liberty in Black's Law Dictionary 4th edition, it says personal liberty is the right or power of locomotion, of changing situation, or moving one's person to whatsoever place one's own inclination may direct, without imprisonment or restraint, unless by due course of law, not code. Because remember, code is not law. In Self versus Ray, they talk about this. They say, revised code of Washington is not the law. Code is actually a constructive contract. And in Graham versus Cummings, they talk about this, saying a constructive contract is where duty defines it instead of the contract defining the duty to be performed. Constructive contracts are fictions of law adopted to enforce the legal duties by actions of contract where no proper contract exists, express or implied. So, when traveling in non-commercial intercourse, there is no enforceable contract with the state of state without one's consent. One's consent is given by silence, by compliance without claim of right, and complying when asked for the driver's license and handing it out the window, thereby giving tacit agreement of engaging in commercial intercourse. So as long as you claim your right to travel, do not hand them your driver's license indicating that you are operating commercially, because you only need a driver's license if you're operating commercially. So by handing that to the police officer, you're saying, I'm operating commercially. So as long as you do not hand them your driver's license and you claim your right to travel, then you are not bound by this motor vehicle code, which is a constructive contract.
My man, Graham v. Cummings, this case is about stocks and the purchase of the Safe Harbor Match Company. It's also called contract law and has nothing to do with civil or criminal law. And you didn't agree to the laws when you handed your license out the window. You agreed to them when you got in your car and you drove somewhere.
And the United States Supreme Court has held multiple times that the right of locomotion, the right to remove from one place to another according to inclination, is an attribute of personal liberty. In Robertson versus Department of Public Works, they say complete freedom of the highways is so old and well established, a blessing that we have forgotten the days of the robber barons and toll roads. And yet, under an act like this, arbitrarily administered, the highways may be completely monopolized. If through lack of interest the people submit, then they may look to see the most sacred of their liberties taken from them one by more or less rapid encroachment. In Murdoch versus Penn, they say a state may not impose a charge for the enjoyment of a right granted by the federal constitution, and that a flat license tax here involves restraints in advance of the constitutional right secured by the First Amendment. And then in Shuttlesworth versus Birmingham, they say if the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage the right with impunity. And in Cruden versus Neal, they even say this: every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. So, if somebody makes a bunch of rules and says, hey, you have to follow my rules, no, actually you don't. You don't have to follow anybody else's rules unless you consent to following those rules. Now, why have so many judges defended our constitutional right to travel? It's because any judge or magistrate who does not comply with his/her oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. Obviously, a judge does not want to be engaging in treason, so they're going to do their best to defend your rights. The Constitution is a charter of negative liberties. It tells the state to let people alone. It does not require a federal government or the state to provide services, even so elementary a service as maintaining law and order. And that's exactly right. We just want to be left alone to live our lives how we want to live them. We just want to be free to do what we want. We just want the government to leave us alone. Stop trying to control everything we do, constantly harass us. And some of you are probably thinking, I like the motor vehicle code. It keeps us safe.
All right, he's hucking out the bullshit faster than I can catch it over here. So we're going to do this rapid fire for the next section. Papa Cristo versus Jacksonville is a case where people were being arrested and charged with crimes of theft simply because they happened to be in an area with lack of evidence in all cases, thereby restricting their liberty to be places arbitrarily. Robertson v. the Department of Public Works is about a trucker being denied the permit to run loads between two cities. They found that the local authorities were arbitrarily denying him a permit with no reasoning for why he should not be allowed to do what others before him have. Murdoch v. Pennsylvania was about Jehovah's Witnesses handing out books and pamphlets to the city of Jeanette, and a local ordinance requiring them to pay for a permit to solicit donations or fees for the books. And it was found to be in violation of the First Amendment. Shuttlesworth v. Birmingham was about a protest that was denied a permit to protest on city streets or public ways. The case was about freedom of speech and the right to protest, and again stated that they can require a permit for such things, but that it has to be uniformly applied, and the rules cannot be arbitrarily decided at the whim of city administrators. Basically, they got caught discriminating against pro-black protesters. Cruden v. Neal is about a man who fled conscription in the Revolutionary War, and it was about determining whether the man was a British citizen or an American citizen. The judge was saying they can't make an American if he removes himself from the state and did not take part in the institution of America. Cooper v. Aaron was about desegregation of schools, where white judges were not allowing black children to attend schools by granting state officials the right to ignore federal laws. It's treason because they were not following the laws of the federal government in doing so. Olmsted v. United States was about them wiretapping people in Prohibition, and it was around if them wiretapping them and recording them amounted to unreasonable search and seizure. And that case decided it didn't, because at the time it just didn't. I think it would now. But also not about driving. So as you can see, none of these cases revolved around the right to drive a vehicle. They were all about different things. Sounds nice though when they put it in that little package.
And some of you are probably thinking, I like the motor vehicle code. It keeps us safe. I don't want people driving around with no driver's license. That sounds dangerous. Well, if you think about it, would you let your child drive without any driving training? Because I wouldn't. Even if driver's license were not required, there's no way I would ever let my child go drive a car without any training.
Oh, don't worry, everybody. The children will be trained. And even in a society that requires driver's licenses, we still end up with scenes like this, though.
I'd be like, all right, well, first, I'm gonna either personally train you how to drive this car and drive with you and watch you drive until I'm confident you're a competent driver before I actually let you drive. Or I'm gonna have them take a course online and learn how to drive. And then once they've passed that course online, then I would start driving with them. And once I see they are a competent driver, then I'd let them drive. So people would still be getting trained to drive. You just wouldn't have to pay for a license to drive.
Oh, great. So now we're at the mercy of whichever idiot trained the last person. Fantastic. I think I'm going to end it there for today. If you made it this far, think about hitting the like button, maybe subscribing, and even becoming one of my fantastic patrons or members. Thank you very much, and have a good night.